I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we focus solely on estate planning. So today I want to talk to you about springing financial powers of attorney. Well, to begin with, estate planning is about more than preparing for the inevitable. A good estate plan should also consider the unexpected, because as we know, life happens. Your plan may have detailed instructions for what happens to you when you're no longer around, but what if something goes wrong while you're still alive? If you can no longer manage your affairs, you will need somebody who can act on your behalf and in your best interest. A financial power of attorney, or often called a POA, is a legal document that lets you designate a trusted person to make financial decisions for you, so they can sign checks or open bank accounts, collect your mail, things of that nature. A financial power of attorney can be immediate, meaning somebody else is authorized to act for you now and into the future, or it can be called springing, and that is, it is effective only if and when an event occurs. Usually it's when you become incapacitated or unable to make decisions for yourself. Now, while every estate plan should feature a financial power of attorney, a springing financial power of attorney requires a little more nuance to overcome its limitations. Additionally, even when carefully written, a springing financial power of attorney can pose problems that may not be easily resolved. That said, some people dislike the idea of making a financial POA effective immediately. They prefer to have a financial POA kick in only when it's absolutely necessary, and that's called a springing power of attorney. A springing financial power of attorney is conditional. It springs into action when you become incapacitated. This is different from an immediate financial power of attorney, which is not conditional. An immediate financial power of attorney is like an active permission slip that gives another person broad legal authority to take over your responsibilities the moment that it's signed. By contrast, after a springing financial power of attorney has been signed, it remains inactive until it is actually needed. So when exactly is a springing financial power of attorney needed? Well, generally speaking, it is needed when you become incapacitated. Now, incapacity can mean a lot of things, including mental illness or mental deficiency, physical illness or a disability, could be advanced age, it could be drug abuse, or unusual events such as being kidnapped or disappearing. The financial power of attorney will usually define incapacity. Your doctor, or depending how you set it up, your doctor and a second physician must then examine you to confirm that you meet that definition of incapacity. When they sign off that you're medically incapacitated, the springing financial power of attorney then takes effect. So let's talk about what happens when a springing financial power of attorney kicks in. After a financial POA springs, the person you have nominated to handle your affairs, known as the attorney-in-fact or an agent, is now allowed to do what you would have otherwise done had you not been incapacitated. With any financial POA, whether it's immediate or springing, you can give the agent wide discretionary latitude to act on your behalf, including managing your day-to-day affairs, handling your investments, filing your taxes, collecting your mail, and operating your business. But you can also set up a financial POA so that the agent's power to act is limited to a particular activity or activities, such as paying your monthly bills. Now, in addition, a financial POA can be revoked in the future when it's no longer needed. The document should specify the exact language for revocation. It might state that you have the authority to revoke the financial POA anytime that you're not disabled or incapacitated, but keep in mind, though, that revocation may require medical verification. Any signed financial POA is automatically revoked when you pass away. So let's talk about some potential issues with a springing POA. So giving somebody else authority under a financial POA involves some risk because they're typically not subject to ongoing oversight by a court or a third party. The agent can abuse their powers and make decisions that are not in your best interest. Not having a POA is also risky. If you become incapacitated without a financial POA, your family may need to petition the court for a conservatorship or guardianship, which can take months and cost thousands of dollars. In the meantime, until a conservator or a guardian is appointed for you, it may be impossible for anyone to manage your most important financial affairs. Setting up a springing financial power of attorney helps avoid issues related to incapacity without giving your agent premature access to your affairs. But you should be aware of some of the following issues. The first issue is just a lag in the effect of the POA. A springing financial POA does not take effect until you've been medically determined incapacitated. This process takes time even when no one is disputing your capacity. Another issue that comes up is the uncertainty about your incapacity. Now, disputes may not arise about your level of incapacity if you're in a coma or if you suffer a serious debilitating injury. But disputes could arise if you're in a state of slow decline, where you have good days and bad days, or alternating moments of clarity and confusion. Doctors, family members, and the agent could be in a disagreement or outright conflict about whether you are incapacitated. Family members could challenge your incapacity in court. Until the uncertainty about your incapacity is settled, the agent has no authority to act. Financial institutions. Let's talk about the issues that come up here. Banks may be nervous about granting access to a customer's account and have been known to decline financial POAs. And in the case of a springing financial POA, the bank may want to see the financial POA document, the physician's letter, and other documents to verify that the financial POA has been activated. Even then, they may refuse to honor this springing financial POA if it is more than a couple of years old. Now, some banks have their own forms for appointing an agent to manage your accounts with that particular bank. So to avoid future trouble, it is important that you ask your bank about their specific requirements. In addition, you may wish to consult your estate planning attorney about how a revocable living trust can serve your needs if you become incapacitated. So let's talk about state laws. Each state has its own laws about springing POAs. For example, as of 2011, Florida no longer permits springing POAs. So your POA must comply with state law and be legally enforceable in your state. If you move to another state, you really want to consider reviewing or updating your POA to ensure that it complies with that state's laws. A financial power of attorney is one of the most important estate planning documents that you can have. If you have concerns that an immediate POA is overreaching, a springing power of attorney may be a good alternative. For further peace of mind, you can speak with your attorney and they can walk you through the other estate planning documents, such as a medical power of attorney, an advanced healthcare directive, and a revocable living trust, to ensure that you have chosen the right people to manage your affairs while you're alive and unable to care for yourself. For help with your estate plan, please, if you live in Massachusetts or New Hampshire, please contact our office and we are happy to help you out. So I hope you found this educational regarding springing powers of attorney. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, and I thank you for watching.